At Scheller College, Peter Swire, that I'm sure you all know, has been leading the charge that has included being the key organizer for this very important conference. I'm very proud of the work that my faculty does in this particular area as they go on updating the rules and coming up with new practices with this amazing new world of technology and the internet. So far today, as I was looking at the program, you have looked at issues, MLA issues at the intersection of law enforcement, intelligence, and military. And now our esteemed keynote speaker is Bruno Gencarelli, and he's going to talk about achieving individual privacy and international security cooperation in a shifting landscape. Bruno Gianelli is the head of data protection for the European Commission in the newly created International Data Flows and Protection Unit. He was in charge of the Commission's work in the area of privacy during the decisive years of legislative reform and the EU-US negotiations. In that capacity, he led the Commission's delegation in the interinstitutional negotiations with the European Parliament and the Council that resulted in the adoption of EU data protection reform. He was one of the lead negotiators of the EU-US Privacy Shield and the Umbrella Agreement, the framework for transatlantic data flows between US and EU. Mr. Gencarelli previously served as a member of the European Commission's Legal Service as an assistant to a judge at the European Court of Justice after having practiced law in the private sector. He holds degrees in law and political science and teaches and publishes in the area of EU law. Mr. Gencarelli's keynote will be followed by brief comments by Andrew Woods and Susan Hennessy, both of them leaders on MLA reform. Please help me welcome our keynote speaker for today.
Thank you. Thank you very much for these kind words, and thank you for the invitation. Thank you to Peter, to Alistair. I'm very happy and honored to be here with you today. You could have hardly chosen a more interesting and timely topic. I'm saying that in both general terms and from a transatlantic EU-US perspective. At a time when our respective systems on both sides of the Atlantic are faced with and are trying to address similar issues in the digital world. We already discussed cross-border access to evidence, to electronic evidence, cybercrime, encryption, but also online radicalization, hate speech, just to name a few. So yes, as we discussed this morning, there are differences between our systems, but more than differences, there are common challenges, and that's what brings us today here. These are all issues that are testing our existing legal concept, our existing legal regimes, and procedures. Again, on both sides of the Atlantic. And an issue for which there are no obvious or easy or one-size-fits-all solution, but for which we need creative solutions which are operational, practical, because as we heard this morning, we are talking about law enforcement cooperation, we are talking about intelligence cooperation, we are talking about sharing of information between our military organization, and of course solutions that also fully comply with our respective constitutional requirements, including when it comes to the protection of privacy. That's why an event like today's conference, bringing together various perspectives, is so important, and that's why I expected to be essentially on a listening mood to bring those ideas back to Brussels. And I will try to keep my remarks as brief as possible, also to have an exchange, an interactive exchange. What I would like to address briefly are some recent developments and achievements and some possible future prospects in our transatlantic work in this area from the European Union, the European Commission perspective. And let me start by stating the obvious. Personal data exchanges are an integral part of our cooperation in law enforcement in particular, and therefore an integral part of our collective security. In an interconnected world where threats rarely stop at national borders, and where at the same time a very broad and an increasingly broad range of human activities are increasingly relying on the processing, the collection of data, but also the movement of data, the swift exchange of personal information is essential for an effective response to such threats. But to be effective, to be reliable, such exchanges, such transfers of data must also be underpinned by robust privacy protections, including, if you think of the use of the information which results from the exchange of data, the use in court proceedings. This is more true today than ever before, because of the technological developments we also touched upon this morning. More true than ever before as privacy issues, including issues surrounding the international transfer and the international exchange of personal data, are subject to much greater scrutiny compared to the past. These, and I think Professor Swai said it, these are no longer technical issues that are discussed within a small group of experts. These are often seen as societal issues that are part of the political debate and that are increasingly litigating courts on both sides of the Atlantic, from New York to Dublin and Strasbourg and Luxembourg, etc. That's why today the question of the relationship, certain will say the dilemma between security and privacy, is not so much a question of tension or a question or binary question. To put it in plain language, this is not, it's none of your business versus what have you, why do you need to hide something? Or if you are, to put in plain language. What security expectation and privacy protection are not a mutually exclusive consideration, but rather complementary and mutually and can be mutually reinforcing elements. That's what we have done when we have reformed privacy legislation in Europe. There has been a lot of discussion about I would say, commercial part of our reform, but we have also adopted what we call a directive in EU law, which harmonizes the rules applying to collection and processing of data by law enforcement authorities. Because the assumption is that to have effective and rapid and swift and reliable law enforcement cooperation, you need also common standards when it comes to privacy. This also is essential to build trust between different law enforcement authorities acting in different jurisdictions. This is true within the EU, and it's true also across the Atlantic. I think that to mention another example, which concerns directly the US, the passage, the adoption last year of the Judicial Redress Bill by Congress, extending to European certain specific judicial redress avenues under the 1974 Privacy Act, is another recognition, acknowledgement of the nexus between common privacy principles and the deepening of our law enforcement cooperation. This example, this reference to the Judicial Redress Act brings me to the first key transatlantic development I wanted to briefly touch upon. The so-called EU-US Umbrella Agreement, also known as the DPPA, Data Protection and Privacy Agreement, that concerned the exchange of personal information as part of law enforcement cooperation. After 4 years of negotiation, that agreement entered into force last February between the EU and the US. And I'm mentioning that agreement because it's a quite remarkable development that can, I think, inform a lot of, a number of the conversation and discussion we will have today. Remarkable development in several respects. I want to mention 3 aspects. First of all, by concluding the first ever international agreement in this area, the US and the EU have not only shown that they can bridge differences, and some of the differences we discussed today, and they can do so in a particularly complex area, because law enforcement cooperation, because of differences in criminal law procedure, is a particular, for instance, is a particular complex area. They have also shown, the EU and the US, that you can enhance law enforcement cooperation by agreeing on a common set of safeguards. And they have finally set a major precedent. This is the first ever agreement in this area, a major precedent at a time when there is an emerging demand for the development of international standard in this field. At the European Commission, it is certainly our intention to use the EU-US umbrella agreement as a model for similar agreements to be concluded with other important law enforcement partners. It is an important agreement, and that would be my second point, also from the point of view of its scope. It horizontally covers all types of personal information, information about suspects, victims, witnesses, convicted individuals. And it does this horizontally for information, personal information, which is exchanged between the US and the EU, between the EU member state and the US, for any law enforcement purposes, from the prevention and investigation to the prosecution of criminal offenses. Such exchanges will now be subject to a harmonized and comprehensive set of rules, of privacy rules and privacy safeguards across the Atlantic. Having such a common framework in place between the EU and the US is a major improvement compared to the previous situation, the situation prevailing until last February, where information exchanges in the law enforcement context were subject to fragmented, often incomplete rules resulting from a patchwork of multilateral, bilateral, national, sometimes sectorial instrument, leading to legal uncertainty, and therefore exposing also those exchanges to potential legal challenges, which is neither good neither for an effective protection of the data and for an effective law enforcement cooperation. What is also interesting is the legal technique used by this agreement. The umbrella will not replace existing agreements between the EU and the US, or between the US and EU member states. There are dozens of agreements that have been concluded over time. The umbrella agreement is not requiring to renegotiate those agreements. It doesn't require, for instance, to renegotiate the EU-US MLAT or the France-US MLAT. But it will rather fill in the gaps by supplementing, complementing existing agreements with when and to the extent they lack some safeguards. Therefore, this agreement is immediately operational and can immediately deliver its benefits while ensuring continuity in law enforcement cooperation and greater certainty, and this further building the trust between law enforcement authorities, which can work on the basis of a clear set of common safeguards. In addition to this retrospective function, the umbrella has also a prospective, a forward-looking dimension by establishing a safety net in terms of safeguards, a baseline for future law enforcement agreement. It will facilitate the conclusion of such agreements compared to the situation that prevailed until now, where each time we would negotiate an agreement, we would have to negotiate afresh these safeguard protections and the various related provisions. That's, again, an important facilitator in terms of law enforcement cooperation, while, of course, also and primarily ensuring the necessary level of protection. And this again concerns any future law enforcement arrangement between the EU and the US, between the EU member states and the US, including, because this will be discussed in the afternoon, any possible future arrangement that may be developed for cooperation, not only between law enforcement authorities, but also between law enforcement authorities and other actors, such as private entities. Any such arrangement will have to be in line with the umbrella. In parallel to the umbrella agreement, the EU and the US have also recently concluded a new arrangement on personal data exchange across the Atlantic as part of commercial transaction for commercial purposes. I'm referring, of course, to the EU-US Privacy Shield that has replaced the Safe Harbor. This new arrangement has been in place since August of last year, and after 7 months of existence, almost 2,000 companies, US companies operating in EU and transferring data to the US, but also EU companies operating. Almost 2,000 companies have signed up or are about to sign up to this framework. What is relevant for discussion today is that the Privacy Shield contains, for the first time, for such type of commercial arrangement, rules and safeguards, assurance commitments on access to such data. So data which is in the first place transfer for commercial purpose, and which is then accessed for legitimate law enforcement, national security, or other international or other public interest. Because I think the conversation we are having today concerns both public authority to public authority transfer, but also access to data, which is, and we know how this is important and relevant, which is in the first place collected and transferred for other purposes, such as commercial purpose. So having these rules in place is a very novel aspect of the whole discussion on privacy across the Atlantic. This includes novel, innovative, some will say creative instruments, such as, for instance, the so-called new ombudsperson, which is a new redress mechanism, independent from the intelligence community, and who is responsible for following up complaints and inquiries by EU individuals on national security access. This is a significant development in an area where, at international level, there is either no mechanism at all to address these issues, or these issues are exclusively dealt in a government-to-government dialogue or format, when such dialogue exists. This shows again, and that's why, and sorry if I'm maybe spending a bit too much time on these aspects, but this shows again that between close partners, we can and we should address even difficult issues, and we should and we can find a mutually acceptable solution. These two agreements, or arrangement, the umbrella agreement, which is a proper agreement, and the privacy shield, have enormous potential to strengthen the transatlantic cooperation in law enforcement, to strengthen the transatlantic trade, and reaffirm our shared values. In a moment, as I said, where there are discussions at international level on what should be the standards in terms of in the field of privacy. Now that they are in place, we need to ensure that they work, they function very well. And I want to mention briefly two aspects in this regard. First, these agreements have been negotiated and have been developed in a certain legal ecosystem. They have been built on the basis of a certain legal and regulatory environment that needs to be maintained. I've already referred, for instance, to the Judicial Redress Act in the context of the Umbrella Agreement. When it comes to the Privacy Shield, the assurances provided by US authorities on access for national security reasons are clearly an essential element of the framework. And as the European Commissioner responsible for justice, Commissioner Jourova, said while visiting the US and meeting her interlocutors in the new administration 2 weeks ago, maintaining, I'm quoting, maintaining the limitation and safeguard in this area is crucial. For instance, there would be no privacy shield without Presidential Policy Directive number 28 and the setting up of the ombudsperson. And we will also, she added, follow closely this year's debates around the reform, the reauthorization of Section 702 FISA and how this will or can affect the data of Europeans. In other words, every piece of this puzzle, and this complex puzzle, matters and can have implication for the overall framework. And that's precisely why, and that's the second aspect I want to mention, the forthcoming first annual review of the Privacy Shield is so important, so crucial. The Schrems judgment was mentioned this morning. One of the lessons of the Schrems judgment by the European Court of Justice is when we are putting in place such arrangement, we have to have systems of periodical monitoring, because the level of protection may evolve for all sorts of reasons in the EU or in the foreign system. And we have to ensure that a certain finding which is made at a certain point in time is still valid. That's why when negotiating the Privacy Shield, we have included this annual review. And sometimes I hear some concerns about the annual review, as if this would lead necessarily to, in a certain sense, reopening the negotiation. Personally, I wouldn't like that also for personal reasons. I've spent sufficient time negotiating that deal, but jokes apart, let me be very clear, it's exactly the opposite. The review is an essential element of the stability and continuity of the shield, also in light of the case law I've just referred to. It is a sort of checkup or health check to assess that everything is in place and functions well, and to address any question in time before the question becomes a problem, and we then run into the type of safe harbor saga we have all gone through. When she came to Washington 2 weeks ago, Commissioner Jourova agreed with Commerce Secretary Ross, because the Privacy Shield is on the US side, administered by Department of Commerce, that the annual review will take place in September this year, after the summer. To make this a successful and meaningful exercise, we will need the active engagement and contribution of all interest parties to the review and to the success of the Privacy Shield. This includes, of course, public authorities, regulators, enforcement, but also business and civil society, and we will reach out to those different actors to prepare the annual review. But our work, and I'm coming to the end of my remark, our work clearly does not end here. And that's also what makes today's conference so interesting and timely. I'm referring here in particular to the work the European Commission is currently carrying out on digital evidence, e-evidence. Today, access to electronic evidence is often a key element, sometimes even the only lead in investigating and prosecuting crimes, especially serious crimes, organized crimes, terrorist-related offenses. Access to such type of evidence raises many questions, from jurisdictional issue to due process issues and privacy-related issues. This is true within the EU, where our member states have taken in this field, in this area, a divergent approach, as regard, for instance, the use of different connecting factors, and also the admissibility of such evidence in court proceedings. The issues become even more complex or tricky at international level when the data is stored in different other jurisdictions. Amongst our member states in the EU, there is a growing consensus for developing a common approach on this with clear criteria. And the member states, what we call in the European Union, the Council, has, which gathers all the EU member states, have asked the Commission to come forward with proposals or policy options on three sets of issues: improving cooperation with service providers, make mutual legal assistance regime system more efficient, and propose solution to the issue of determining and enforcing jurisdiction in the cyberspace. To that end, a dialogue with relevant stakeholders has been launched and is ongoing. So this is clearly not about finding a one-size-fits-all type of solution, also because we are looking at different types of instruments, from traditional ones, such as mutual legal assistance, to alternative tools, such as direct requests to companies. A broad range of approaches and tools are being considered, going from very practical improvements within the existing rules. For instance, training practitioners on the use of mutual assistance, on complying with the evidentiary requirements, such as probable cause of in the foreign system, forms, standardized forms, etc. So from practical improvements to more long-term solution. What is clear for us is that this work, as Commissioner Jourova also declared in the context of a recent visit to the US, in carrying out that work, we are fully committed to further pursue our transatlantic dialogue on these issues as well, both with US authorities and other stakeholders, in particular Internet service provider. And I actually see also in this room many faces I meet in Brussels when we have our meetings on these issues. But as I said in my introductory remarks, I'm here mainly to listen. So let me thank you for your attention.
Andrew and I are going to exercise the privilege of being able to ask a few questions first, and then we'll open it up to audience questions to allow about 15-20 minutes. So I'm sure you will have lots of follow-ups, so I'll let Andrew ask more questions.
Sounds good. So first of all, thank you for these super thoughtful comments, and it's delightful to hear your optimism about the prospect for cooperation. Optimism is much needed in this space. I did leave your comments feeling a little bit both more optimistic and pessimistic. You know, when you're hiking and you see the top of the trail and you think, I just have to make it to there. And then you get there and you see around the bend and you realize you've made it about 5% of the way. That's kind of how I feel whenever I hear people talk about the umbrella agreement, because on the one hand, it's an amazing accomplishment. On the other hand, there's so much work to be done. So I wanted to just ask you two questions about the umbrella agreement. One is maybe smaller or more technical, and the other one is a bit bigger and probably more challenging in the long run. So the first is just, are you optimistic about its prospects should there be or when there is a legal challenge? You brought up Schrems. I wasn't going to do it, but you did. So what happens to the umbrella agreement in the context of a court of, a European challenge? There are all sorts of challenges that could happen here, but I'm curious to hear from you what happens in the European court to that agreement. And then secondly, I wonder if you think, whether you think it does enough, because my fear is that the service providers in the room are seeing a world in which the demands for evidence, the volume of demands is so high that increased cooperation and smoother and more efficient cross-border cooperation isn't going to be enough, and that set of principles to make demands directly in country. If that's the case, then this is a small step in the right direction, but we need to work on establishing what those principles are to allow for that kind of in-country demands. So I'm curious about both aspects of this.
Well, first of all, should I answer now, or do you want to? I don't know if this is about climbing a mountain, but we have always been, I have always been clear that this is not and will never be a walk in the park, because of the level, and that's right, the level of scrutiny. As to, litigation in this area is part of our almost daily bread. It is known. We are in an area which is, as I said, essential from a fundamental rights point of view, and from many other points. Litigation is part of life. I think that when you're talking about litigation, this concerns more the privacy shield and the umbrella agreement, because as far as I know, there are no pending cases on the umbrella agreement. But there are indeed pending cases, both at national level, actually not really on the privacy shield, but on things that are relevant to the privacy shield, and at European level. Well, my answer to that is that when we took the decision of adopting the privacy shield, we took it because we had negotiated the privacy shield in light of the criteria set forth, laid down by the court in Schrems, which, by the way, in the meantime had been consolidated in European legislation because the regulation on privacy, etc. And that's why we have those assurances and commitments when it comes to public authority access, which was something that was completely missing from the safe harbor. That's why we have new redress mechanism, which concerns both this public part, ombudsperson, etc., but also, more importantly, because the daily, I don't know if it's more important, but in terms of daily functioning of the privacy shield is, first of all, a commercial arrangement, and it's very important for us that if individuals have doubts, concerns about the way their data is collected and processed, first of all, by commercial operators, there are effective mechanism to handle those complaints and resolve them. And that's true both for, I would say, what we call commercial complaints and inquiries that concerns public authorities' access. The annual review is another innovation that we have introduced precisely to answer to criticism from the Court of Justice. So we believe we have a significantly strengthened arrangement, and an arrangement that complies with the case law of the court. Then we'll see. See you in court if ever we have to go to court. But again, that's how the U.S. system works, that the EU system. We are systems, fortunately, based on the rule of law, and these issues can be brought to court attention. On what you said, indeed, the umbrella agreement only covers, with one footnote, law enforcement to law enforcement exchange, which are still very important, especially when it comes to content data. The issue of direct access is indeed, and that was what I very briefly mentioned in the last part of my remark, because this is ongoing work and I cannot say much more, but this is exactly what we're working right now. And this is clearly the next chapter of our work, both within the EU and across the Atlantic. The US is, of course, essential for that, because service providers are essentially based in the US. So I totally agree with this, and we have requests, as I said, both from our member states, which are a big user of this data, also from companies which want to have a more legal certainty in this area, which don't want to be faced with conflicting obligation in deciding whether or not to answer or respond to such requests. So that's exactly what we are working on right now. I hope I covered your question.
One quick follow-up on that. So just as to that process that you said you can't say much about, could you say more? Can you? I'm curious to know what does the process look like? Who's involved? What are the principles that are guiding it? Anything that you could share with this audience?
Well, it's a quite open and public process. As I said, there's some participants and some representative of companies, but we also have civil society representative because first we need to map the issue and to define options. That's what our member states have asked us. We are not yet in a phase where the decision on this is not going to be taken overnight. And as I said, this covers a broad range of issues, which goes from very practical arrangement, which can be done within the existing rules, because a lot of this is based on cooperation and voluntary cooperation. Whether we can streamline this, whether we can have standards, forms, etc. But that's a decision that still needs to be taken, whether we need to do more in terms of more hard law instruments, knowing, of course, also that ideally this should be done in a way which is convergent, because we don't want certainly to create, this is all about creating more legal certainty. And plus, this exercise has two dimensions. Within the EU, our member states have very different approaches right now on this. In terms of the connecting factor, which is the authority which is responsible? The one of the establishment of the service provider, the one of where the service is provided, where the victim is located, etc. So that's, for instance, one part of the issue. Defining what is the relevant connecting factor. And as I said, this goes to a very wide range of issues, but the Commission is going to, in June, report to the Council on this, and I think at that point I should come back here, and I will be able to answer in more detail to your question.
So I'll be quick so the audience will have time for questions. I agree with Andrew that you presented really a very optimistic vision of sort of what the next year or two looks like. It also struck me that you were describing a pretty complex landscape of PPE 28 and 702 reauthorization, privacy shield review. This is against the backdrop of I think it's not controversial to say, a very different American government than we've seen in the past, particularly on these issues, and it's not necessarily clear where they fall on some of these questions. At the same time, European politics are in a particular moment of flux. So I'll ask you to be a pessimist for a minute.
Mm-hmm.
Do you have sort of the alternative worst case scenario? Are there the things that you're sort of looking at? These are signs that the process is not going well, that we're headed in a negative direction. What are sort of the red flags or the signals for you?
Well, if I sound too optimistic, but optimism is part of this business, but if I sound too optimistic, I didn't want to sound too over-optimistic. I said we have to be proud of what we have achieved. If one thinks where we were, not 10 years ago, but 3 years ago or 4 years ago, then you understand the importance of what has been achieved. But what I also said very clearly, and quoting our Commissioner, which expressed the message of the European Union and the Commission, this, to work these arrangements, to make this arrangement work and stay in place, there are a number of things that needs to be complied with, both by the companies and public authorities, and which are based on reforms that have been undertaken, for instance, on this side of the Atlantic, where in case these foundations would disappear, or being removed, or being substantially amended in a way that would go in the wrong direction for us, the sustainability and the viability of these instruments would be in question and would be at risk, also in light of legal challenges. So it's cautious optimism. What I also note is that, yes, you have had a change of administration. I think we have also realized this. But these instruments were developed with very strong bipartisan support. Example is the Judicial Redress Act. You couldn't pass an act in Congress without bipartisan support. These instruments are also considered on this side of the Atlantic very important, including for US business, including for the trust between the necessary trust, which is, as we know, a key element of the digital economy. You need users to trust the way their data is collected and processed. Also, this moving to the umbrella agreement, this agreement is a very important part of again, the trust which is needed for the day-to-day work of our law enforcement people. And again, this is in terms of, and sometimes it's, observers don't realize how comprehensive it is, because it covers everything. So from the police of, I live in Brussels, district of Brussels, investigating on the terrorist attacks of last year, to even much more banal or petty criminal offenses. But this is that's why it's called an umbrella agreement. It's something which covers all law enforcement cooperation. And I think that both sides, and I hope, and I believe that both sides know very well the advantage and the benefits of such instruments. And that's why it's our role to when there's a new administration, to remind this and to remind what are the conditions for the continuity of these instruments. But what I can say, we have now, I can draw the lessons of a few months of implementation of these instruments. Indeed, there have been changes. Not only in the administration, there have been sometimes new texts that have been adopted and that have raised all sorts of concern on our part of the Atlantic. What is very important, especially when you are, in a certain sense, bound by this complex puzzle of different rules and agreements, is the immediate, if not immediate, very quick communication. That because we have different systems, it's very important when something like this happens, for instance, an adoption of an executive order, that there are explanations, that this is important to avoid certain misunderstandings, probably. This is also important because, as I said, we are subject to a lot of scrutiny, not only from courts, from Parliament, national Parliament, European Parliament, etc. So when you are getting even closer, it's even more important, like in a couple, that you speak to each other. And so now this is a new administration, so people need to be appointed. It's also part of human contacts. Contacts have to be established. But I would say that this is a very simple, practical, day-to-day aspect of this issue. But this need to communicate and, in a certain sense, factor in that some domestic developments actually have implications, wider implications. That's, I would say, essential.
Great, so we can go to audience questions.
Yes, my name is Larry Keller. I'm with the Scheller College of Business. And excuse me if I'm taking you further down the road of pessimism. And I really want.
I thought that America was the land of optimism. So.
But I also want to really get more specific in terms of what was just raised in the last question, and that is the recent action by the U.S. Congress and President Trump to repeal FCC rules safeguarding personal identifiable information of users from the use of that information and sale of that information by internet service providers. Does that specifically raise a concern with you in terms of meeting the objectives of the Privacy Shield? And in general, does it signal perhaps a change in viewpoints as to the importance and priority of privacy that might undermine your future actions?
In few words, first question, no. Second question, yes. It indicates a change of music, at least. As to the impact on the Privacy Shield, there is no such impact for 3 reasons. I'm going to be very quick on this. First, those rules didn't exist when the Privacy Shield was adopted. They actually never enter into force. That's why Congress could, in a certain sense, repeal them. Second, they concerns companies that from the outset, from the start, could not join the Privacy Shield, because to be able to join the Privacy Shield, you have to be subject to the jurisdiction of either the FTC or the Department of Transportation in terms of oversight, including of privacy rules. And companies subject to the FCC are not within the scope of the Privacy Shield. Those might look as very legalistic answers to your question, but they are very important. But more importantly, the rules that are here at issues, it's about transparency of information, it's about rules on sharing of information, here, in this case, not between public authorities, but between different commercial operators, which might even want to sell the personal information that they have collected, are actually subject to specific rules in the Privacy Shield. Those very points are covered by the Privacy Shield. So, in a nutshell, this doesn't concern and doesn't have, as such, any impact on the Privacy Shield, but those are developments. As I said, these instruments were developed in a certain context and landscape, and I would say music, and we are, of course, very attentive to those signals. Yes.
I think we have time for one more question.
Hi, I'm Professor Swire's student. I have a question about onward transfers. Under Article 7, it discusses them. I'm just wondering when you guys, like when the EU and the US get together and discuss whether or not they will be studying somewhere on an onward transfer, do you guys weigh in human rights? There was no human rights clause in the umbrella.
The onward transfer. So you're talking about onward transfer in the umbrella agreement. So the onward transfer provision clause in the in the umbrella agreement is based on a very well-known concept in law enforcement cooperation, is that the authority which originally transferred the data has to give its consent. So if Germany transferred data to the US and then the US wants to transfer data to Canada, to give you a friendly example, the US would have to go back. Can be organized in different ways to Germany. This is traditional concept of law enforcement cooperation, and we have. Actually, I think I even have the text of the umbrella agreement with me. I should always have it with me. We have also said that in considering whether to give its consent, the authority which has originally sent the data has to take into account a number of factors, including the level of protection which is ensured in the third country. But our system, like the US system, accepts that there may be cases, for instance, very specific cases, when human life is, for instance, at stake, where you might have certain consideration prevailing over others. But that consideration about the level, the continuity of protection is in actually the second paragraph of Article 7. Peter, I'm very impressed by your students that they know articles of the umbrella agreement that says when deciding the competent authority which has originally transferred the information, when deciding whether to give its consent or not, has to take due account of all relevant factors, including the seriousness of the offense, the purpose for which the data is initially transferred, and whether the country or organization in question ensures an appropriate level of protection of personal information. Plus, it may also subject the transfer to specific conditions. For instance, we might, with more difficult countries, say you can use that data, but only for those purposes. Or you can use the data, but it cannot be used in a proceeding that can lead, for instance, to give a controversial example, but an important for the EU, to death penalty, for instance. So that's what is in the umbrella agreement. But that balancing exercise has to be done by the competent authority which has originally transferred the data. And there are ways, meaning our authorities and the US authorities are working on a daily basis together, and they have through also practices, etc., find ways to organize this. But this is indeed a very important provision of the umbrella agreement.